Okay, the court is joining now.
All right, good morning, everyone. Apologize for the slight delay. There have been a host of filings here in the last few business hours, and the court was attempting to at least get a thumbnail familiarity with what was filed so we could have a discussion with a level of understanding of the court with what has recently been filed. But we'll get to that in more detail shortly. We are on the record in the case of Amethyst Payne versus DETR. The case number is Civil 20-755. As with our prior hearings, we are communicating through simultaneous audiovisual means as anticipated and allowed specifically by Nevada Supreme Court Rule Subpart 9 and administrative orders of Nevada's Second Judicial District Court. This hearing is open to the public through a link on the court's website, as well as through the court's YouTube channel. I am Judge Breslow, physically located here in Washoe County, Nevada. At this time, I ask Ms. DeGaynor to please identify herself on the record as the court clerk and indicate where she is joining us from. Ms. DeGaynor.
Amanda DeGaynor, court clerk, located in Washoe County, Nevada.
Thank you. And then the court's certified shorthand reporter, please, Ms. Zinn.
Isolde Zinn, Washoe County, Nevada.
Thank you, Ms. Zinn. Let's turn now to the special master appointed by the court, Mr. Guanasso.
Yes, good morning, Your Honor. Jason Guanasso for the record, calling from Skagit County, Washington.
Well, we can hear you loud and clear all the way from the great state of Washington. Plaintiff counsel, beginning please with Ms. Jones.
Good morning, Your Honor. Leah Jones, calling from Washoe County, Nevada.
Thank you. Mr. Thierman. Mr. Thierman, I believe you're still on mute.
Thank you. Mark Thierman for plaintiffs, also located in Washoe County, Nevada.
Thank you very much. Mr. Rod, on behalf of the state of Nevada.
Greg Ott, calling in from Carson City, Nevada, also joined by Administrator Kimberly Goff, Chief Economist Dave Schmidt, and ESD Counsel Troy Jordan.
Very well, thank you. And then Mr. Whitney. Also, you're still on mute, sir.
I apologize for that, Your Honor. And this is Robert Whitney calling in from North Las Vegas and Clark County, Nevada. Thank you.
Thank you very much. All right, well, let's get right to it. We all readily recall the status of last week's hearing and the resulting order. The order directed certain actions to be taken by DETR with a deadline of this past Tuesday, 2 days ago, and then indicated as well that a follow-up hearing would occur today, both to gauge compliance with the order, as well as to go over other issues that remained as identified in the order with respect to the UI-PUA dichotomy, the first filer issue, the retroactivity issue, things like that. I've seen, although I haven't reviewed thoroughly, and I'm not prepared to hear argument on or make a decision on any effort by the plaintiffs to have this court hold the state in contempt. But I'm aware that a request to that end has been recently filed as of late yesterday afternoon. I'm also aware that the state this morning filed a status brief as to efforts it has made to comply with the court's order, as well as further efforts it has made to address the concerns indicated by the court at the hearing last week that did not amount to a specific order directing activity by way of a writ of mandate. So what I'd like to do first is please hear from the state of Nevada. Let's go through efforts at compliance with the court's order, and then a status update, please, on the issues that the court also indicated it would like to see progress, if not perfection on. Who would like to speak to that, please, on behalf of the state?
I'll speak to it, Your Honor, and appreciate the direction with regard to how you would like to receive the argument or the status update. I will go through these in the order that you directed and you laid them out. I want the court to keep in mind that with regard to the three categories and really with regard to all the claims, some of the solutions and some of the efforts that you have put in or that have been undertaken in the past week are not going to bear fruit in a week or 2 weeks. They are longer term solutions. I think it's fair to characterize or to use the analogy that this is not a blizzard that we are preparing for, it is a winter. And so we need to be able to build capacity for the long term. So some of these solutions, though they may not be immediate, are aimed at making sure that we have the capacity to serve people throughout the extent of the pandemic. So
well, let me respond to that. There may be a point in time where we talk about the approach, we talk about the effort being made, we talk about, in greater detail, we talk about the realities of compliance. I'm here right at this point, though, to simply gather facts, at least for the first part of this hearing. So, for example, what I'd like to know is what effort has the state undertaken to comply with the court's order on specifically those three buckets, the two buckets of or categories of people who are apparently not receiving payments, but the court directed payments to move forward. For example, let's take the issue with a classic case, for example, of the Uber driver who was attempting to earn a subsistence living, but was denied benefits because they hadn't completely stopped working. And you'll recall both the court's comments and then the resulting order to direct the state to pay those based on the court's interpretation, fairly made, as I thought then and continue to think now, that we should interpret that to mean if it substantially interfered with their ability to earn a living, as opposed to completely stop, because that would just encourage people not to attempt to earn anything and might hurt those that need their services. Okay, so where are we on that, Mr. Ott? Are those claims being paid? Does it involve a large amount of people? Has the state reached out to the Department of Labor to gauge its temperature on how they view that, things like that? So if you could please speak to that first.
Sure. So first, with regard to the Department of Labor, the first thing that we did was to send the court's order to the Department of Labor so that they could identify any concerns or possible inconsistencies, obviously wanting to safeguard the continued existence of the program. Shortly after the hearing, the Department of Labor issued UPL 1620 Change 2, which addressed this issue, not in the exact same language that the court used. The court used substantial interference. The DOL talked about a diminution. So the language is not identical, but after conversations with DOL, they believe that the intent of the court and the intent of DOL are the same, which is not to punish someone who has continue to work, but at a reduced level, assuming, of course, that they are monetarily eligible.
Well, I consider that great news, that the Department of Labor, in the court's estimation, is proactively and correctly viewing it in a way to not penalize people who are trying to continue to earn something. All right. So as a result of getting that feedback from the Department of Labor and review and consideration of the court's order, Mr. Ott, how close is the state now to fully complying with that piece of the court's order?
The state is in compliance with that piece of the court's order. They have reviewed all of the claims that would have been denied for this, that would fall under this category. There have not been claims that have been denied for this category. And there have, in fact, been claims paid where there has been a diminution. So the claims have been reviewed, and there are no longer any individuals who are not being paid who solely on the substantial interference or significant diminution of work.
All right, hold the thought for a minute, Mr. Thierman or Ms. Jones, before we move to the next bucket of claimants. Does the plaintiff agree, disagree, or somewhere in the middle on the representation of Mr. Ott that people are now being paid or have been paid that would otherwise fall in this group?
Well, this is Mark Thierman for plaintiffs. From what I can tell from the report and the declaration is that the people who have been denied or we thought denied because they were working part-time rather than full-time, their earnings part-time exceeded the amounts they are allowed to earn anyway, and therefore that was now or was then maybe the real reason for denial. And I have no data to support or deny that, but I assume that DETR's telling the truth. You know, if we get into discovery on that category, it looks like to me that if that is true, and if seems to me that the regulations may be counterintuitive, but if that's what the regulations say, then that's what the regulations say, and I don't fault DETR for following it. So
Okay.
I guess we reluctantly but agree, subject to verification of the underlying facts. But it seems to me that that category is a non-category as of now.
All right. So, and you mentioned a report and affidavit. Do you mean what the state just recently filed?
Yes, Your Honor. And I should say, just for the record, because I know there are a lot of people watching this, and my constituency or my people, my potential class members, putative class members, I'm taking the position that both DETR and the plaintiffs are at least agreed on the idea that we want to see the most benefits paid legally, consistent with regulations to the most people. How we view those regulations, as I said before, is a little bit different, but assuming that they're telling the truth on this, yes, we can see that this has been done.
All right. Well, let me put a finer. Go ahead, Ms. Jones.
Sorry to interrupt. I just want to preface our questions here, and perhaps DETR can explain this, is when they say all the people have been paid that are eligible under that program, that does it or does it not include people that are still in the appeal process? Because although, as Mr. Thurman said, it may be correct that these people earned more wages than they would be able to and be entitled to the UI benefit amount. But if they have some argument about that, such as, you know, you didn't use my right 1099, or the quarter that I provided wasn't right. I just want to make sure that those people aren't lumped in to the people that DETR is saying, okay, we paid all these people, because anybody that has an appeal right now is not being paid. And so I don't want the court or the attorneys or the people watching to be confused when DETR throws out these numbers saying X amount of people have been paid, when that may be true, but that doesn't mean that there's not another group that has a significant number of people that may have appeal rights and that are trying to appeal now that DETR has finally set up the appeal process?
Well, Ms. Jones, let me respond this way. And with respect to this hearing, as with the other ones, we will be a little bit less formal because the court is trying as best it can to gather information it can use to properly make decisions consistent with the law. And so because a lot of you have significant information gap with the court, I welcome being educated on this from multiple directions. But I want to clarify something. This is not a business meeting right now. This is a court hearing to determine whether, at least preliminarily, DETR is complying with the court order. If so, great. If not, why not? And if the court determines that there's a non-compliance, the court may set it for a hearing on what penalties, if any, should be imposed. But with respect to the singular issue that we started out with, which is that group of claimants who were denied because they did not completely suspend operations as viewed by the state. Suspend equals stop. And I directed a different approach to that. Specifically, suspend meant substantial interference. As subjective as a standard as that is, you know, it's something more than a tiny bit, and it's less than complete shutdown. It's substantial interference. The state indicated that they double-checked the court's math with the Department of Labor. I've got a decision from the Department of Labor, if not completely aligned, parallel or consistent with the court order, and they are moving forward to pay those claims at this level. And I'm not aware of any suggestion from plaintiff that those people who would otherwise fall into that group are not being paid, other than, as you suggest, Ms. Jones, those that were denied have an appeal going forward, and you're curious what their status is. So we can get to that if needed a little bit later this morning. So Mr. Ott, you don't have to respond to that because that's not really what I'm here about at this point, but if you would like to say something, I'll give you the opportunity. Go ahead.
I did want to say one further point. It was a point that Department of Labor raised on a phone call with them about the court's order. They did not respond in writing, but we did have an opportunity to have a conversation with them. They pointed out that their language in UPL 1620 change 2 is limited to individuals described in section 2102 sub A3A 21 KK of the CARES Act. And that is in our brief. And I bring that to the court's attention because they were concerned that the language used in the court order might be broader than what they had intended in the UPL. And I just want to make sure that the court is aware of any conflicts that DOL has identified. So not asking for anything, I just wanted to put that on the record.
Well, let me respond to that. So, you know, the court order is clear. If you're seeking to avoid total and complete compliance with the court order, there better be a request in writing as to why the court should allow slightly disparate treatment. I don't have such a motion. I do have a brief that was filed approximately an hour before the hearing and just made available after clerk review, and it gets up the chain to this court a matter of minutes before this hearing started. But my point being that absent a further order of the court, or either in writing or on the record, I'll expect from the state of Nevada complete compliance with court order. But again, if there's a reason the court should deem a slight variance, I'll certainly consider. Now, before we move on to the next group, the much larger group, those to whom payments had been started and for some reason stopped, Mr. Guanasso, before we move on, anything to add further that you've come across in your review or discussions with respect to this first bucket of claimants?
Thank you, Your Honor. No.
Very good. So let's go to the second piece of the court's order. In the court's order, the court indicated that payments once started could not be withheld and must be restarted unless one of four things was happening. The applicant had not filed the weekly claim, which is a prerequisite, or number two, the applicant had earnings in excess of that for which benefits would otherwise be available. Or number three, the state had, not just a mere sense of or sniff of possible fraud, but something more than that, something solid, something that arises to, clear and convincing evidence, which is generally the fraud standard in civil law. And so if the state, had that, or strongly suspected that, or had a reasonable basis to believe that such existed, then payments could stop once started. And then finally, the court said, or number four, not and, Mr. Thierman, but or number four, until such time as the applicant is afforded an opportunity to be heard. Now, the reason the court made that portion of its ruling is because the court was relying on the United States Supreme Court case Java, and then in a different context, but the principles of which still apply. And then from the court's fair reading of Department of Labor guidance thereafter, the court extrapolated from that and found that unless the state could demonstrate that someone fell into one of these four possible exceptions, then payments ought not to be stopped. And if they were stopped, they needed to restart. So I'm just looking quickly at the brief that was filed this morning by the state. Mr. Ott, if not you, who can address where we are on that and what the continuing issues are?
Certainly, Your Honor. I'll speak to that as well. First job was to identify the list of individuals who had payments stopped to them. That number was identified as 30,647 for all reasons.
Hold on, sorry, just so the court's clear. So slightly north of 30,000 people, payments began and then they stopped. Is that right?
Correct, yes.
All right, please continue.
Okay, so of those 30,000, those with excess earnings or no weekly claim, that was 7,407.
Of the 30.
Correct.
Right, so the state had a right to stop those payments.
Correct.
All right, continue.
Okay, the next group is claims with fraud flags. And so that is 22,387.
So again, payments started, the state became alerted of possible fraud issue and payments were stopped. All right, but of that subset, how many did the state have more than just a flag, but evidence that arose to a level at the heightened standard that the court suggested?
So there's a number of different flags that can issue for fraud. And we're talking about 22,000 claims, so we're talking about broad categories.
Yes.
So what DETR did to try to best comply with the court's order as quickly as possible was to evaluate which claims could be released. Now, it's possible for a claimant to have multiple flags. So you could have multiple IP addresses, you could be out of the country, you could have a social security number with multiple filings. There could be multiple different issues going on that would prevent payment. So the release of a category may not necessarily result in a payment of a claim if there is a other more serious category. So DETR identified two categories of large batches of claimants that did not, or of flags that did not meet the clear and convincing standard related to two-party authentication. One group had over 8,000 claims being held for it, and the other one had 6,000 claims being held for it. And these are not these are not mutually exclusive, so there's overlap there. And I think if I read the court's mind, what you'll be most interested in is how many of these releases actually resulted in someone moving towards payment status. And we believe that the amount of people that will be released to payment as a result of this is around 3,000.
Well, let me hit the pause button again. Well, that's certainly demonstrating a level of progress. Why were they not released to start the process for payment earlier this week?
So Administrator Gah can give more detail on this. In order to determine whether the clear and convincing standard is met, sampling had to be done within the individual groups to make sure that if we take a sample of 20 people, we don't get 10 people who are fraudulent. So that was one issue. Administrator Gah, if you have anything to add.
Well, what I'm hearing, I'll hear from her in a moment, but Mr. Rott, what I'm hearing is it took more time. It took more time to go through and identify those that had the flags, then identify those where the flag could come off, and then identify those that payments could be restarted, and then do a level of sampling to make sure that there's some quality control. And that all didn't happen by Tuesday. Now, Administrator Gah, you're still under oath. Do you understand that, ma'am?
Yes, Your Honor.
All right, thank you. Would you please speak to that issue? Because obviously, you know, I'm pleased that you're moving forward. I'm pleased that you're attempting to comply with the court order. I'm not asking for any disclosure of any type of confidential or proprietary efforts the state is undertaking to identify fraud and to stop the bad guys from obtaining benefits that the law doesn't provide for them. But what I want to make sure is that I've got earnest attempts to comply with the court order. So if you would, please, ma'am, speak to that in relation to this particular issue.
Yes, Your Honor. The way you described the process in order to define the group that was the least likely fraudulent and then do the analysis on that is exactly as you described. We had to find the universe, separate it out based on the number of fraud flags, separate out those that had higher significance or weight of indication of fraud, and so on. And it took a number of days and a complement of staff to do that analysis. We also used every tool that we had available to make sure we captured the entire group and triple checked numbers several times to make sure we weren't leaving people out of those groups. So we did our best to try to make sure we captured everybody. And then we've already requested from our vendor to do an en masse, essentially a release, which is done through a operation change request. And that is already in process. That process takes several days to accomplish before it gets to a payment status. So it's a technical complexity and lift in order to move large groups in the thousands of people to a pay status. So we've been working closely with the vendor as well as the staff analysis to quickly identify as quickly as we could those that we could release. The others that remain held do have significant indicators on them and multiple indicators on them. We continue to do additional analysis on other groups as we try to sieve it down, and we're actively working on that every day. And we will continue as we find them and can validate to the best of our ability that they aren't fraudulent to release those in batches as we come across them. We're pretty confident that there are fewer and fewer as we go.
All right, thank you for that overview. Let me ask you this then. As to those several thousand people that are now going to receive payment, that payment is being directed to them, when can they expect to actually get payments in their account or otherwise receive I'm not sure if debit cards are being sent or electronic deposits or however they're being paid the benefits. When should they expect to get them?
Traditionally, traditionally the timeline is 7 to 14 days based on the vendor. We've asked them to try to expedite this. Some of them could see payments as early as Monday. I can't be 100% certain when all the releases of the batches will occur. It depends on the technology and how it pushes out, because they have to do a lot of back-end work in the system in order to execute this. That DETR staff then go in and validate the files to move it to the bank and so on and so forth. So it's a several-day process, but the earliest possible date, I believe, would be Monday, because banking, they don't have a banking file that goes on the weekend.
All right, let's talk again, Mr. Ott. Thank you, Ms. Gott. Mr. Ott, let's talk again about the larger than the bucket of still people caught up in the fraud review. Now, just so we're clear, the court intended that if people are being prevented from receiving benefits because of fraud concerns, and as you've explained it, Mr. Ott, it can be because of one issue, it can be because of several overlapping issues, and that have to be peeled away before a determination is made that somebody has a valid claim. But what the court's expecting is that you need more. Again, I'm repeating myself, but you need more than just a sense. You need more than just a whisper or a light concern. I'm directing the order contemplated that you need something more. You need more than just some evidence. You need more than just some concern. You need, solid evidence that approaches a fraud standard. Now, I realize that takes time to develop, and I realize there are a lot of applicants, and I realize there are a lot of concern. And we talked at the last hearing, and I'm aware the court can take judicial notice, again, of other states and the concerns and the experiences they are having with fraud. But nevertheless, people await their funds. And I'd really like to see that bucket go from possibly 3,000 or more to a greater amount as soon as you can free that group up. So Mr. Ott or Ms. Gah, who can speak to how we can move forward to make that happen more quickly?
Your Honor, this is Kimberly Gah. I'm not certain that there's a large group left within the fraud flagged bucket that is not fraudulent. We are working directly with our Attorney General, local law enforcement, Secret Service, FBI, and the Office of the Inspector General, as well as the National Integrity Center, and working through the flags that they've identified. And many of these flags that have been placed on these claims have been reported by these entities. This is not just DETR saying we believe that this information is suspicious. It's getting reported to us by law enforcement as well. So I want to assure the court that we are taking the order seriously, that we need more than just a whisper of a suspicion, that it's absolutely, these things are being reported by banking institutions and the cadre of the law enforcement community. And we take that information from them and look at the groups of claims that have been identified. And many of these claims have been reported by multiple law enforcement entities and the National Integrity Center. It's not just a one-off situation. I assure you that that's not the case. All
right, thank you. Mr. Thierman or Ms. Jones, would you like to respond with your sense of things at this point?
Yes, Your Honor. I don't know if I'm allowed to put up the report itself that defendant DETR filed, but on page 5 of 12, and if I can, I'll
well, I'm there right now.
Okay. And I'm having a little trouble understanding because maybe it's just me, or maybe it seems to say, in an effort to expedite the payment status, the maximum amount of the remaining
Well,
22,000.
speak slowly because this is being reported.
Okay. Maybe can I screen share it, or is that possible, or not?
If you can do so, I don't prohibit it.
Okay. Well, I'm trying to share. Okay. So, is it working? And do you see it or not?
I do.
Okay.
Yes.
So from here down to here on page 5, rather than read it, it looks to me, what it seems to be saying is that there were 3,000 claims of fraud investigated and none met your standard. And I can't tell from this exactly how many people are in that fraud bucket. But I do know that the supplemental, or the earlier, I think it was 2015 memo from DOL, says that in cases of fraud, predetermination cases, not post, you're supposed to call the plaintiff or call the claimant, ask for their explanation, and then make a judgment, which I believe was never done on any of them. And that's the DOL's recommendation. Again, Java, I don't think the DOL has abandoned Java, nor can it. And I think that this, to the extent there are other buckets, or there are other people in this bucket, unless there are specific, this is what Your Honor was saying, rather than statistical, but specific to that person, claims of fraud, that there are at least predetermination, asked what's going on and given a chance to explain. Post-determination, it should be the usual process of, a hearing. They have to be paid. And what this seems to be saying is we have a 0%, and I could be reading this wrong, of 3,000 that are actually fraud. But because we've been using these other databases, which brings into effect that whole other statute, which requires these kind of notices and specifically says you cannot make an adverse determination based on these other databases without confronting or giving a chance to explain. They're still holding up something. We don't know how much because of fraud.
Well, hold on. Let me tell you my takeaway from reading this page and hearing Administrator Ga and Counsel Ott. And that is that they went back and looked, and indeed about 3,000, that's on line 6, 3,000 that had been held up, they now have realized do not meet the court standard and are available now to be paid.
That's
so
good.
3,000, it says ESD has located over 3,000 claims that were stopped for review for possible fraudulent filings. These claims were reviewed, and it has been determined that these do not appear to be fraudulent. DETR has requested that the vendor release these for immediate payment at the earliest possible time. And as Administrator God just said, earliest possible time means as fast as they can get the vendor to release the payment to this large of a sub bucket of group of claimants, which it's moving forward. Hopefully some will be paid as early as Monday, but it could take as much as 10 to 14 days from the go launch signal was given.
But
so that's at least for those 3,000.
Right, but how much, I can't tell from this how many were not paid.
Well, bigger than 3,000, that's for sure. And those are the ones that the court's understanding the administrator to say that there are multiple indicia of possible fraud, and they are being held up for those reasons and consistent with the court's order. Unless Administrator Guy misunderstood you.
Well, to me, it's not consistent with the court order because there are no specifics as these people, nor did they follow the provisions of the DOL 01-16 that says you've got to call these people first and get their side of the explanation. All they did is go back to their databases and say, yep, I got two flags, two probably explainable flags, and therefore, statistically speaking, these are probably fraudulent. Instead of saying, well, how come you have an IP address outside Nevada? Or how come you have, you don't have a two-party authenticating of the phone? And when you went into that last time, the phone could be cut off. The IP address could be a VPN, lots of reasons, but nobody's asking. Likewise, we just got a denial today, which brings up to another point, that tells us absolutely no reason why it's being denied. Denied because you didn't comply. Doesn't say why you didn't comply. And that gives no due process and no chance to rebut. And I don't think you can generalize, and I don't think your order allows for that kind of generalization to the specifics, at least without some kind of at least contacting these people and say, what's the real explanation? I don't think that's in compliance. And that's not due process. We don't do statistical sampling and say, well, 1 out of 5 of you is guilty, so we'll just take 20% and send them to jail. I mean, I made the joke about Minority Report, the Tom Cruise movie, but it's basically that's the mentality. That's not due process.
I've seen that movie.
Oh, good. Well,
Mr. Ott, how would you respond? Because, of course, as we drill down here, the court's pleased that the funds are being released to the 3,000 or so as promptly as the state can do so, contacting its vendor and directing payments to be made. But as to those that still have the flawed indicia, what exactly, please, is the state doing to give the claimants an opportunity to explain away the red flags that are stopping their benefits from being received?
So,
and excuse me 1 second. Mr. Thierman, if you could please go out of screen share mode. Thank you. Mr. Ott.
So to give more details on exactly the fraud process that the verification, I think Administrator Gah can speak to that. I don't have any idea what email or other item Mr. Thierman was relaying. That's not before the court and completely unable to respond to that. But as to your question, Your Honor, I think Administrator Gah can speak briefly as to the normal fraud process without, of course, divulging anything that would tip off the bad guys.
Right. And again, I'm interested in how do people have a chance to be heard and respond to the red flags that may be holding up their payments. Administrator Gah, what steps could they expect to be asked to take at this point?
We've been working with the vendor on an e-messaging mechanism because the PUA system in particular is an all online system. We expect that functionality to be available by next week, and people should be receiving, it could be as early as tomorrow. Again, it's a timing issue with them deploying code and so on and so forth, but we're sending messaging out to individuals where if we need verification documents, for example, if you say you're this person, give us these 5 pieces of information or whatever to verify that. We are in the process of doing that now with the vendor, and it's also included in my declaration that we were already doing that or trying to get that functionality live before the last hearing, and it should be coming to fruition over the weekend. And we expect that messaging to be going out in batches again before sometime next week. So there will be messaging instructing people to do certain things in order to try to comply, to say, here's your opportunity to tell us these are the things we don't have, we can't verify, we can't validate, please provide it. So there is a process in place.
All right, let me ask Ms. Jones her thoughts on that issue. Ms. Jones.
Thank you, Your Honor. Before, I don't want to interrupt the flow of your questioning, but specific to what Ms. Gah was just speaking about, we've had hundreds of emails from people that are concerned that they have received a communication saying, please send the front and back of my social security card, the front and back of your driver's license, your birth certificate, a utility bill, and all of your employee data for 2019. People are already getting that communication. So it sounds like to me that Ms. Gaw has said that that communication has not gone out. And so people are afraid to re-upload information that they've uploaded 3 or 4 times and have sent screenshots showing that it has been uploaded 3 or 4 times, and a Lorica supervisor has confirmed that they have received the uploads, and yet these people are now being asked, almost 20,000 of them, to possibly upload all those documents again. That's a scary, scary thing. And secondly, she said that it's an all online process. Mr. Weinkoop, our plaintiff, was told by DETR that he should not use his computer because it was pinging out of state. He is broke, he was hospitalized, he sold his computer, he has a cell phone only that is about to be turned off because he hasn't been paid for 4 months. What are people that are unable to access the online information system to do? They're not getting a snail mail letter. They're not getting anything that says this is a DETR official correspondence. My question, I guess, is how can people provide DETR with the information when they're so afraid at this point that they've already provided it? They've provided it for 18 weeks now, and now it's going to be another 6 to 8 weeks from what Ms. Goss said in her town hall with Representative Lee yesterday before that process is complete. I know that there's claimants out there that are wondering those same questions.
All right, Mr. Otter, Ms. Gaw, if either of you would like to take a stab at responding to some or all of the questions that Ms. Jones just asked through the court, I'll give you that opportunity. I'm going to assume that Ms. Jones is sharing some of the worst case scenario experiences that have been shared by people in touch with her in her office. I'm going to further assume that the vast majority of people hopefully are not having that type of issue and concern, but obviously some might be. Would anyone like to respond to that from the state? Ms. Gaw or Mr. Ott?
So what Administrator Gaw was speaking about was the ability to have this bulk functionality of communications and requests. Prior requests that have been sent out have had to been done individually. When we talk about process improvement and the ability to expedite the process, that ability to communicate with multiple claimants and large groups of claimants at the same time is the improvement that we were addressing.
Okay, Ms. Gaw, any further response to what you just heard, ma'am?
Yes, we also reviewed the entire database of filings. We have 376,000 unique filers in the system, and we reviewed the database of filers, and only 50,000 of them have uploaded some documentation. So we're trying, again, we're doing the same process as we did with other fraud flags, sift through those to determine who's provided that documentation, who can be released, who all those steps that I previously described. So we're talking a very limited set of 376,000 claims that have been filed that have provided the documentation necessary in order to make validation and verification if that is where these people sit and these flags exist on their claim. I can't tell you off the top of my head what the overlap is there, but I can tell you it's significant. If not all of those people held for a fraud flag are going to have to produce some documentation so we can verify who we're communicating with.
Your Honor, that may be operationally the good thing to do, but that's not what the Supreme Court in Java and Kelly v. Goldberg requires. It's not withhold benefits first and investigate. It's investigate quickly, which they haven't done, and then proceed to pay unless there's specific fraudulent activity that they can say that will stand up on review. And so far to that person, that's Kelly v. Goldberg, man. Before that, Kelly v. Goldberg, because I used to do welfare hearings and for the state of for the Office of Legal Services. Before Kelly v. Goldberg, they used to hold up your welfare payments and then say, okay, you prove you're eligible. And the Supreme Court said you can't do that. It's the other way around. It's an entitlement. It's your property. And that's exactly what Java says. So this is a legal issue. I'm not going to criticize or argue with the statistical thing, but at least what I'm hearing is there are 20,000 people who they have not paid because of this, and they've put the cart before the horse legally. And I think at least we should get that clarified.
Mr. Guanasso, what are you hearing on that issue?
Yes, Your Honor. Thank you. Couple of points in the declaration of Ms. Gaw that preceded the last hearing. She had said that there were 100,000 claims that were flagged for fraud. And so if I understand what's being represented to the court today, 22,000 of those were then evaluated and 3,000 of those were cleared. And that means that roughly 3% of that universe have been addressed in accordance with the court's order. And I think the difficulty is that they're trying to resolve these fraud flags with code and software because they don't have human beings, to go through these claim by claim to verify that they're dealing with a real person versus a person who's committing fraud. And so trying to understand these numbers, Your Honor, at least from my seat, has one been like trying to, nail Jell-O to the wall, with a nail, because the fraud flags that are being imposed by the system, there's, at least from my seat, it's not a coherent rationale. Now, if you were to sit down with the department in a confidential meeting and talk to them about their fraud investigations in a way that wouldn't make public, their process for flagging some of these claims as fraud, it might illuminate, why there's some delay. But we can't do that. Yeah, the only way to really work through all of this, it seems to me, is to have people, manpower to work through this backlog. And as I mentioned in my report a week or two ago, the other states have approached this by getting manpower from other sources, whether it was through the National Guard or through some other means. But this problem, the way that it presents, if the only means to addressing it is through code and through computers, then it's going to be a pretty slow and arduous process. And one other thing I'd like to note is that what plaintiff's attorneys had indicated about people saying that they uploaded information, but then still didn't get the fraud flag cleared or are still waiting for payment. I know I've received a number of emails like that. People are actually sending to my office their social security cards and their birth certificates and screenshots of what they've submitted, which worries me on a number of levels that they're sending my office this sensitive information. But it seems to me there are a number of people who are trying to clear their names of fraud, but there's no real streamlined way for that to happen without manpower to make that happen. And I think that's the real, struggle for DETR, is having the manpower to work through all these to be able to clear the fraud flags and really with certainty be able to say this number of people is in fact fraudulent, this number of people is not. And you know, the only other way to kind of sort through that would be to do a series of mass denials and then give people hearing an opportunity to be heard. I also put that in my report to you as well. But this is gonna, if the sole reliance is on code and getting the computer system to work through these quicker with staff kind of following up and clearing flags, it's going to be a long process, especially if there are 100,000 claims in the universe, 22,000 of which have been analyzed, 3,000 of which have been cleared up to this point.
Your
Hold on. So the issue, though, is what does the law require in such a circumstance? I mean, we intuitively, we all understand the concept, Mr. Guanasso, that with more people involved, and there could be some more direct contact, more explanations received, and the state could work through this backlog. But that doesn't appear on the immediate horizon. As noble as the efforts being made by the men and women that work for the state are, and as well as efforts to increase the staffing, that, as everyone is aware, takes time. And time is not a luxury that we have right now. So the court has already reviewed what I consider to be binding precedent, the jurisprudence, the body of law that informs this area. And I've already made a determination that unless the state can reasonably stop payments to somebody because of a fairly heightened standard of concern that fraudulent activity is ongoing, those payments cannot be stopped. Or if they haven't begun, they need to begin. Now, I want to give some real world leeway to the state, taking into account the realities of the challenge that it's facing. And I'm heartened by a level of progress that appears to have been undertaken in the last 10 days to 2 weeks. I sincerely am. But it seems to the court that it's still a concern. It's still a concern. One thing the court is contemplating at this point is to direct Mr. Guanasso to review with the state exactly how they are making a determination that an application bears so many markers, so many red flags or indicia of potential fraud that the payments ought not to be restarted. And then report back to the court, not with specifics as to what the state is basing the decision on, but whether good faith efforts are being made to make that determination. And then the court can decide what to do. But right now I have the administrator telling the court that many different areas of government and law enforcement are collaboratively working to prevent fraudulent benefits from being paid. The court understands and appreciates that and is glad that those efforts are being undertaken. The concern, though, is that so many people are being captured in this dragnet that people who desperately need income for their personal and family survival are being caught up unwittingly. And so $3,000 to be paid promptly, that's good. But as I've said before, right now good is not just a baseline, it's fairly unacceptable. So let me think about that here a little bit more, and we'll likely come back to it shortly. Let's move, Mr. Ott, please, to the progress that's being made on the first filers, on those that have, and those that sought benefits beginning at the end of February and were denied apparently because there was concern that the pandemic did not affect them to an extent that they would be triggered for benefits, and then also those that are being denied benefits because they still have a balance in the UI program. Mr. Ott, what progress, please, is the state making on those three issues that we talked about at the last hearing, but the court declined at that point to issue any type of an order directing payment to be made.
Certainly. So I will start with what we think of as the UI PUA backlog. And in thinking about how to resolve this, we identified 4 possible things that could be done to resolve this.
Okay.
The first is expressly prohibited by the by DOL, which would be to pay before eligibility has been determined.
This court will not order that, and for several reasons. One, I don't think that's justified, and 2, this court doesn't want to do anything to put the state in harm's way to have this program's benefits for all those that are currently being paid or will shortly be paid to have them pulled. So that's not an option for the court. What are the other 3?
So the other 3 would be to expedite the process by bringing in more resources. The court referenced this earlier. There are efforts in place to do that. Specifically, there's 25 new positions that are being brought on immediately that has been previously approved by IFC and the GFO. So those 25 people will need to be backgrounded and trained, but they will come in to immediately assist on the unemployment side. Additionally, Administrator Gah is submitting a work plan for another 200 positions, subject to approval again of IFC and the GFO. But those would also be dedicated to unemployment side only. That is a work plan like this would normally take a year to implement. Our aim is to get it done in 3 months. Not immediate, but when you're bringing on these sorts of resources, things take some time. Additionally, on the PUA side of things, there is an effort to bring in, as you know, PUA is handled by an outside vendor. So there is an effort to bring in another vendor to assist with the call center and the adjudication on the PUA side. So we're working on standing up that contract to bring additional capacity on that side as well, trying to get that brought on as soon as possible. Again, once that comes on, there will still need to be a train up period to get them up to the point where they can be of assistance. But when we're talking about building out the capacity, those are things that are happening on the PUA side and on the unemployment side.
Okay, what's the third option?
So the third would be to expedite eligibility determinations, because as I understand it, the court is concerned about the amount of time people have to wait to have these determinations. So in communications with the existing vendor, we, and Mr. Gah touched on it briefly, the ability to issue mass communications and mass denials of applications with crossover eligibility. There is an ability that is forthcoming in the next several days to issue these sort of bulk determinations and bulk denials of PUA claims with UI eligibility. So that will allow them to understand they have potential UI eligibility and will need to go through that process. The estimation is about 75,000 claims would be covered by that. Those are PUA filers with possible UI eligibility. So that will expedite the process, not necessarily in a way that gets those people paid, but tells them they need to go to UI to get that determined first. That's the third one.
Yep. What's the last one?
So the fourth one is process improvement. And I kind of leaned on Special Master Guanasso and his staff. And again, thanks to him for being available even while he's in Washington and out of state. We asked him for a sample of some of the people that had reached out to him that were in this UI PUA loop to see if there was anything we could glean from that would improve our process. He sent us over a number of claims. We took the first 11 in a bulk document that he had sent to try to analyze those to see what their status was. So of those 11, 2 were being paid now in unemployment, 5 were being paid in PUA, 3 have possible unemployment eligibility, but we're waiting on additional documents from them, and 1 has possible unemployment eligibility and is waiting adjudication on our side.
Okay, hold that thought. Mr. Guanasso, is that consistent then with what you believe the outcome is or will be with those 11?
Yes, Your Honor. We provided the information to DETR so they could work through them individually as a sample size or a sample group that would maybe help them identify how they might be able to fix similarly situated claims. Yes.
So, for example, these 11, for each of the 11, there are dozens, hundreds, maybe thousands behind those people that have similar type circumstances, which if DETR takes a look at how it resolved or addressed these particular 11, that might be informative of how they address all the hundreds or thousands standing behind them. Is that fair?
Yes, that was the hope that arose from the conversation that I was able to have with DETR and the attorneys and staff there.
So, Mr. Rott, I guess the question is, was DETR able to learn anything that it did not already know, or approach things now differently than it already was by virtue of this random sample that can help improve operations and move things faster?
So the quick answer is not yet. I mentioned that the special master sent over a batch of de-identified claims that were, it was a 144-page document that contained 11 claims. He sent over, or his office sent over additional claims that were not fully analyzed in time to get the information into the briefing and whatnot. There may be process improvements there, but as of the initial batch that was reviewed, we haven't identified process improvements. But we were heartened by the fact that 60% of those people who were identified, or 7 out of 10 were in payment status, and 3 out of 11, the ball was in their court, for lack of a better analogy. And one final thing, we did not communicate the details of these claims back to Special Master Guanasso. These non-parties still have statutory confidentiality under 612. So despite the fact that he gave us the personal information, we did not communicate that back to his office to verify.
Very good. Thank you. Okay. Well, Mr. Thierman, Ms. Jones, I know what you're going to say, but I'll let you say it anyway about this all sounds good, but we need to get money into people's checking and bank accounts and hands as soon as possible. But go ahead and tell me what you would have the court do on this issue, the UI, PUA conundrum. What would you have the court do right now, Mr. Thierman?
Well, first of all, the idea of a mass denial a la an insurance company bad faith is the most draconian abuse of due process. That is, these people, unlike the private sector, these people are due a due process obligation from the very get-go to have their case adjudicated individually. And yes, if there's a pattern, if this equals that, we'll say, then that may be a reason for adjudication, but suspicion, that's not a reason for adjudication of negativity. The presumption is on the wrong side. The presumption should be on payment, not the other way around. And I don't think the DOL is inconsistent with that. I think the DOL language, which is amorphous at best, simply says, no, you can't assume they're entitled to it. But unless you have what Java says, until you determine that they're not, and once you determine that they are, and then you determine that they're not, you've got to keep paying. And if it's okay to put up another screenshot, if I can, let me see if I'll do that.
It's okay, but I mean, aren't we talking about how we move people more quickly through the UI program to get benefits there, and then they can transition over to the PUA?
Sure, but this has been going on for how many weeks? And the problem is, if I could, be so blunt, that DETR puts out a letter, okay? And it says, we have completed a review and investigation of your claim, and we have determined that you have other program eligibility. That's a determination. So either they have the other program eligibility, in which case they ought to get it, or they don't. And if they don't, then the PUA kicks in. And if they do, the other program kicks in. So we have done nothing to get out of the box. And just to say, well, our systems don't talk to each other, and it's on the applicant 16 weeks later. I mean, let's face it, it's nice to talk about something that's going to happen in 3 months, but if we're coming to take away your house, or you're going to lose your kid because you can't provide suitable living arrangements, or, I mean, these people are very depressed and somewhat angry, and I don't think they're unjustified in those feelings, considering they were promised that they were going to get this money, and they counted on it. So when they say that they have other program eligibility in writing, then they ought to pay them under that other program, and at least the $600 for the FPUC, which kicks in on either program. And, you know, what they're saying is, we have 2 bank accounts, and we can't decide which one they come from, so we're not going to pay you on either one.
Well, we know all this. I mean,
okay, but the answer is then just assume that that once they issue those determinations, right in Java land, they start getting paid. And I don't care where the state pulls the money from, which bank account. That's my solution.
Well, you've just heard, look, I'm not, you know, my job is to be the fair referee here. I don't play favorites, but I want to make sure I understood what I heard. The state is aware of the court's concern. The state is aware of the court's continually noting the human suffering that is occurring as a result of the pandemic and the economic toll that it is having on men and women in Nevada. The court's equally cognizant of the efforts the state, a bit understaffed, quite overwhelmed, and with an unprecedented pandemic, is trying to do. Now, by this hearing, I want to know the level of compliance with the court order, and I'm expecting as close to full compliance as we can get. And I want to see some serious progress toward moving claimants through the system. And so really, that's the goal of this hearing. Now, I want to, among everything else, I want to make sure I hear this directly from Mr. Ott and or Administrator Gah. But once people are cleared for payment under the programs available, to the extent they've had to wait, they will get back paid for all amounts they were due from the time that the law says the payments should have begun. Mr. Ott, is that a fair statement?
Yes, Your Honor, it is a fair statement.
Because, you know, the news headlines are suggesting that, you know, payments or benefits are running out. They're soon to expire, end of July. Congress is arm wrestling over what the new benefit package or extension will look like. And I want to make sure that people who hear what we're doing in this case understand that to the extent payments are to be made lawfully to them under one or more of these programs, they are to get all that is coming to them, not merely just from that period of time they start payments being made forward.
I don't know how it can make that representation. I mean, I know the federal government, if you got a budget for a year, you got it for the year, and if you don't spend it, you lose it. So I don't know what the next fiscal year will bring.
Well, this is not the area that I am often in, but I'm assuming that Attorney Ott, Attorney Whitney, or Administrator Gah can assure those listening that there are funds that are already earmarked for or possibly in the possession of the state of Nevada that can be used to bring all these payments current to those to whom they're due. Am I mistaken, Mr. Ott or Mr. Whitney?
No, Your Honor, you're not mistaken. And just to clarify, even though the FPUC program may be set for sunset, that doesn't prevent someone who is approved after that from getting the FPUC for the time that it was.
Okay, so that's key here. That's key to the court's concern, because for anybody whose payments are being held up, who is later determined that payments ought to have been made or will be made, they are to get all the money that the law otherwise provided for them. So that's, I know, a concern of many people.
Well, I think it still is. I mean, I don't see a DOL memo. I don't see an administrative memo from the federal government saying, don't worry, you can claim this next year. And I just have an opinion from a state official who can't apply for what the federal government is or what isn't going to fund. And I frankly find that, given the history, there's good reason to doubt the predictive abilities of the state on this issue.
Hmm.
But whatever,
Mr.
nobody can afford to wait anyway. I mean, one of the key factors here, we keep going around and around, is they say they haven't made a determination, and their letter says they have. That's key. They have made a determination. Otherwise, why send out these kind of letters? So they're stopped. They say in their own letter, they made a determination. Well, hold them to it. That's what Java says. Not, oh, we made a determination, but we really haven't. That's doublespeak.
Your Honor, Administrator Gah can speak to the contents of the letter in a little bit more detail. If Mr. Thierman wants a representation from the federal government, he's going to have to ask the federal government. There's nothing we can do there. But she can speak to the
let me hear from, please, Administrator Gah, if you'd like to speak on that.
So there's two different programs we're talking about. We're talking about standard unemployment insurance and pandemic unemployment assistance. The program eligibility criteria for both programs are different. And when we issue the letter saying that somebody has other program eligibility, per the CARES Act and per the guidance from DOL on the coordination of program payment, eligibility for UI is the predominant program, and pandemic unemployment, and then state extended benefits. So it's very specific that says if somebody has monetary eligibility for standard unemployment, they must go through that eligibility process and be paid out of that program first.
Well, we've covered this ground before. So the question is, how do we get people paid from the one or the other as they desperately await benefits?
So the 76 or 75,000 that we were estimating, those are people that applied for PUA and have UI monetary eligibility. So we are sending them messaging telling them that they have this eligibility and they must apply under UI in accordance with the law. We will be then processing them through the UI eligibility process. Right now on standard UI, we're hovering around the 90 percentile. Those eligible for UI benefits are being paid at about a 90%. That is consistent with pre-pandemic payment level. So prior to the pandemic, if you looked at what we were paying people on any given day, it was about 90% of those eligible in like January. So we're already there in UI. So we realize that this is a bulk of people that will be sent to UI to determine eligibility, but we don't have a way to skip that process. That's the federal requirement, and that's our only remedy. So we are adding staff.
Yeah, well, we need to move them. When I say we, the concern of the court is they need to be moved through much more quickly. And I've heard the efforts that are being made to get more people there, more bodies, more concerned Nevadans to help people through the UI claim process. But there is it seems to the court, an enormous group of people that need to get through UI as required before they can access the pandemic unemployment assistance programs. Mr. Thierman, how is that a violation of the court order? How is that something that a writ of mandate could cure?
Yes.
What remedy from the judiciary do you want when the law is clear that these people have to get through their UI first?
Your Honor, first of all, it's not contemptible because it's not covered by the mandate of the mandate. It's covered by the let's explore what we can do to make this better portion of your order. And the simple answer is when they've made a determination, and it says in writing, we have determined. Okay, and this is not a monetary eligibility. This is the letter is entitled, if I can get up here, Pandemic Unemployment Disqualification Determination. It's a determination letter. It's an eligibility determination. When it says we have determined that you are not eligible because you are eligible for something else, then what's the point of going through the process of something else? I mean, it should be a rubber stamp. In fact, what they're saying is we've determined that we can't determine. Otherwise, what does that mean? I mean, the judicial answer is you should extend your order to cover those people who are not only paid, but who have issued determination letters that they are eligible. And that's what Java did. I mean, I don't know if the people in Java were ever paid. I mean, they talk about the payment stream and that was cut off, but we don't know if there was in fact a payment stream. It doesn't really matter. The payment stream is a ministerial act. That comes from the controller's office, not from DETR's. And when they say, oh, 90% of the people are eligible, but they've already ruled out the people who are not eligible, and 90% of the people who are eligible getting paid is kind of bad. You should get 100% of people eligible. That's what eligibility means. So, you know, unless they're dead or they don't meet the looking for work criteria that's futuristic and not retrospective, I don't understand why it isn't 100%. But of the claimants, how many are getting paid? So what they're doing is kicking the can down the road, and on the pretext that you can't get PUA because you're eligible for UI. Well, if you're eligible for UI, it's a tautology. If you're eligible for UI, then get UI. I don't know what you are applying for. Now, if you're not eligible for UI, then don't put it in the letter that you are and don't deny PUA. So I think the answer to your Honor's question is simple. Those people who have an eligibility determination that says you are eligible for UI get paid the UI. If you don't mean it, don't say it. And if you do mean it, then follow through on it. What else is there? And the second kind of letter we get, which is kind of interesting, which is this is also a written formal determination. It says here, pandemic unemployment qualification determination. If I can put it on my screen if you want.
Sorry.
If I can figure out how to do that again. I think that's it. Is that it? Yeah. It says, we've convened a review and we have determined your claim is approved.
Hold on, Mr. Thurman, that we didn't get a screen.
Did I not do this right? I'm sorry.
That's all right.
It says you're sharing. Is it not doing it?
No, not for the court.
Exhibit 1 and 2 to the declaration of
So, Mr. Thurman, do the court a favor and undo what you just did, because now the court can't see anyone.
I'm sorry. All right. Stop share. I apologize. The letter says, the second letter says you're eligible. The first letter says you're not eligible because you're eligible for something else. The second letter, exact words are, we have determined that your claim is approved as you meet the qualifications. Well, if it's approved, you meet the qualifications, pay.
Okay. Hold on, Mr. Thurman, for one moment. Ms. Clerk, can you see the attendees in this Zoom webinar?
Yes, Your Honor, I can.
Mr. Ganasso, can you see everyone?
Yes, Your Honor, I can see everybody.
Okay, you're back.
Okay.
Mr. Thurman, your frustration is palpable. The people that have not been paid, their voices have been heard.
But you asked a question.
But the question was, with respect to the role of the judiciary here, to order the state to do something it's not doing, to interpret the law in a way the state may have not been interpreting it, to order the state to stop doing something that it is doing. I still want to know, if you were writing the order of mandate on this issue, how would it read? And then I'm going to ask Mr. Ott and Mr. Ganasso to discuss their view.
All right. So if I could, let's see if I can find your
because
order.
let me put this in context. The two biggest buckets of people that are not being paid right now, and that's not to minimize the people that are in some of the other buckets, but the two largest buckets right now are those that have been flagged for fraud and those that are being directed to process their claim through the standard UI program before becoming eligible for the pandemic benefits. So these are the two that grab the most people who allege that they've been denied benefits the law entitles them to. So with that in mind, Mr. Thierman, how would you write the order of mandate if the court were inclined to go that way?
All right, so let's go to your own order previously issued. We can jump through the findings of fact and all that, go to the order itself. It says, all right, the first order says, once payments have started, first thing, and I would add, or a determination of eligibility has been approved or issued.
Okay.
A written determination, if you want to be, I mean, obviously mechanically, it's easier to enforce. A written determination of eligibility in any program, I don't care if it's UI or PUC or whatever. And I just add that phrase in, and then all of a sudden these 75,000 people get swept in with the first bunch, which, 5 to 7 days, they're going to start cutting checks for, hopefully.
Mr. Rott, what's your position, please?
So we've talked previously about how the letters that he's described are not determinations of eligibility. So if you did as he just drafted, that would not affect the people that he is asking you to impact. Just to clarify the issue here, there could be a person who has gone on the dark web and bought an identity in another country, and that identity may have wages that would render that person eligible for unemployment. That bad actor in another country could file for PUA, and the first denial they would get would say you have monetary eligibility in UI because that's the first check. There are still fraud issues. We know this is not a legitimate person, but the first check is unemployment eligibility, so it would send them back to unemployment. Then they would be held up later for fraud, but we know this is not a legitimate individual, but they would still get the letter that directs them to be denied from PUA because of monetary eligibility, because that's the quickest way that we can sort those people out, and it's the most expedited way. So there's overlapping issues here, and just briefly, the letter that he's talking about has been corrected, hasn't been issued for months. So to the extent the court is concerned about that letter, it's no longer being issued. We talked about the issues with that letter previously, and the possible confusion there. So that's a bit of a red herring if we're trying to think about solutions for people going forward.
Okay, Mr. Guanasso, what are your thoughts?
Thank you, Your Honor. I think the thing that strikes me listening to this conversation and being a part of this process the last several weeks is that everyone has the same shared goal. The department and the plaintiffs all want eligible applicants to receive benefits. And this court wants all eligible applicants to receive benefits. What I believe the court has attempted to do in its previous order and is looking for help with now is how to get eligible people the benefits that are due them. And the process right now of the point and the counterpoint that you're hearing isn't really moving the ball down the field to the ultimate goal. And
well, you heard Administrator Gah explain some of the ways that things that are in the works to move the ball down the field. Is that not encouraging?
No, the progress that has been made is encouraging, Your Honor. I just think that it would appear to me that having the plaintiffs and the defendants working on these, sharing information real time, so that these issues as they're arising, and I know the plaintiffs are getting emails every 30 seconds, because I'm getting emails every 30 seconds, it appears, and I'm getting my phones are ringing, every 2 minutes with an applicant who has, a story that you've likely already heard or read about in the pleadings and or my report. People are coming to my office asking for relief and help. Friends and family and even people that cut my hair are asking for help. And so, unless the plaintiffs and the department are working together to identify these issues as we're talking about them now, and working together for the shared goal of getting people paid, the court is going to be somewhat of a blunt instrument in accomplishing what everybody wants to accomplish. It would just seem to me, and I think I mentioned this to you before, Your Honor, that getting the parties to talk and work together toward that shared goal would be, would be another appropriate step in this process that has already yielded results, but there's still a lot of people that are clearly suffering. If my phone, if the phone calls I've gotten and all the emails I've gotten are any indication, and they've been overwhelming, such that I'm having to set up another system in my office to deal with that. And if I know the good people at DETR, like I believe I do, and I've gotten to know them better over the last several weeks, I know they want to get benefits to eligible folks, and I know the plaintiffs want eligible people to get paid. Then having some process going forward where maybe we're filing less motions and doing more work, to get folks paid would be an appropriate next step, so that we can work out a lot of these bottlenecks that we've already identified previously, and new ones that seem to be emerging, because as one thing gets fixed, it seems like it creates a different kind of a problem that's nuanced to the code that they're implementing or the new process that they're implementing. So those would be my thoughts for now on those issues, Your Honor. Because I think your question was, if I were if Mr. Thierman were to give you an order, what would that look like? And I don't know that there's an order that you could issue over and above what you've done now, other than just ordering everybody get paid and we work things out later, that would speed up this process. So absent that kind of an order, then having the parties really work together to resolve these issues, so that we're able to work through the backlogs in the different pools would seem to be the appropriate next step.
Wise counsel. All right, before we make some determinations here, let's just go through the other areas that I asked for an update on for purposes of this hearing. Mr. Ott, so I'm looking at the court's order, page 9, line 14, beg your pardon, line 16, what steps DETR has made to move the first filers to the front of the line, so to speak, and then finally, item C on line 17, the retroactivity issue with respect to people who sought benefits for a period of time that really started on leap year day, February 29 through March 5. So what's the status of those, please?
So with regard to the first filers, there's a chart attached to our filing that talks about a total of 67,580 claims fall under the definition of from May 16 through May 24. Of those, 48,093 have currently been paid. Of the remaining unclaimed or unpaid claims, there's about 2,000 that have not filed weekly claims. So that takes that number down to about 18,000.
Hold on one second. So if they're listening, if you're one of those 2,000 that otherwise meet the criteria required to get benefits, make sure you file weekly, right? I mean, if anyone's listening to this hearing and is wondering why their payments stopped, that's the reason. All right. So what about the other 16 or 17,000?
So about 8,000 of those have unemployment eligibility. So
they're in the other bucket. All right. So they're above on the issue we just talked about. So for those of you that have received that letter, of course, without regard to what the court is going to do right now, there's a level of continuing, and I'm not suggesting people have failed, but continuing personal responsibility to do what you're asked to do. And I understand many of you listening will take the position that you've done that and it's been unsuccessful, and you've done it again and it's been unsuccessful another time. But I can tell you that the state has indicated to the court that they're putting more resources on this as quickly as they can do so. And then, so what are the other thousands of people, Mr. Rott?
So of the remaining about 8 or so, there's about 3,200 that are in, it says IP issue in the chart. That's not IP as we think about it in the internet, but it's an investigative process. So some sort of fraud flag has been detected, and they're in the process of being investigated. The other 2 categories are other outstanding issues and no details, which, as I understand it, are a bit of a catch-all, which incorporates a number of different issues. And we can probably speak with administrator or with someone else here to get a little bit more detail on those specifics.
Well, I guess for purposes of this hearing, I don't need to know that. What I'm hearing, though, is of that first filer bucket, those 83,000 plus or minus, if I have that number right, from the first
67.
How many?
67,000.
Beg your pardon. Of those 67,000 that filed in the first week or so, right? 80% or more are already being paid. Several thousand have to go through UI first. Several of them have sort of special handling instructions for one reason or the other. And that gets us down to, a number that's just maybe a couple thousand people. Does that sound right, Mr. Ott?
Yeah, I think 80% is high. I think it's in the low 70s as far as percentage paid, but otherwise I think that's an accurate summation.
Okay. Administrator Geyser, is there anything you'd like to add to what Mr. Ott just said before I hear from Mr. Thierman or Ms. Jones as to why they believe that that's still unacceptable?
No, Your Honor, that's the what Mr. Ott outlined is exactly where everybody is sitting right now.
Okay.
I would say that the individuals that do have UI eligibility are going to be receiving messaging to file an UI or have already received that messaging.
All right. And again, going back to our last hearing, the state recognized, I recall, that there were issues with first filers. There was a glitch in the system, and they were put to the side, I guess, while others who filed later were moved ahead of them. But unless I'm misremembering it, but it seems to the court that progress is being made there, and benefits are being paid. Mr. Thierman, do you view it differently, and if so, why?
Sure. I mean, from what I hear, 3,000 more people got paid out of 69,000 people. That's what I hear. Approximate. So that 25% who aren't being paid, that's good enough. I don't think that's good enough. I don't think that's what the statute requires. And I don't think when you tell someone they're eligible, that's not an eligibility determination. I'm sorry, that's what the words say. And most of the people who you're going to hear from, because I'm going to hear from them, going to tell me they uploaded everything UI wanted, and UI either is sitting on it or has denied them. And they even uploaded the denial back to the PUA and still haven't gotten paid. So we haven't, I don't think, sufficiently advanced the ball, or I'll put it this way, I want to advance it further. And 3,000 or 10,000 out of 40,000 being paid leaves 30,000 unpaid, and that's wrong. And if the whole UI thing is a charade where we give them the letter saying they're covered by UI, but we don't mean it, And that's a denial of due process. I mean, they're supposed to make a decision relatively quick. In Java, they called the other side up, because I used to practice a lot in California. And someone comes in and makes a claim. They call the employer up. If he doesn't answer, bing, the employee wins. If he does answer, they ask a few questions, then they make a determination. Here, they do none of that. They get an application and they sit on it. And then after a while, they say, oh, well, we'll kick it over here. Or, oh, we have these indicia of fraud generally, so we're just going to stop. Just because you can't presume somebody's eligible doesn't mean that once they apply and you can't find anything wrong with it, that somehow that we have to prove they're eligible. And that's what they're doing. They're putting the shoe on the wrong foot. So I don't know if we're getting further advanced or we're just getting around and around. And by the way, this ongoing thing, I don't know what the program is going to be here tomorrow. But even if it is, new applicants, most of the people have applied. So I want to get these people on the payroll or on the benefit roll. And if DETR turns around and says, well, we actually did discover fraud, fine, arrest them. Or actually, they're really not qualified because, actually, the only other excuse is because they're covered by UI. But they're not really covered by UI, in which case they should be covered by PUA. I mean, I don't know where that circle gets us in terms of getting their money back. I've already explained that. So, and these other reasons, so we're not going to have any more, not because of pandemic or not determinations. Okay, great. If that's what's going to happen. I don't know. I just am extremely frustrated. You asked what language I would put in. And I said, you can rely on the written language of DETR itself. And DETR says, no, you can't.
Okay. Last issue was with respect to the people who were seeking benefits for impairment of their ability to work or earn an income COVID-related that predated the first confirmed case in Nevada. Mr. Ott, what progress are we making on that, please?
So I just want to be clear, to make sure that there's no misunderstanding. There was never a unilateral decision to deny people prior to the first date in Nevada. There was I think that was used as an example of something that could be suspicious because if you don't have the disease present in Nevada, it's questionable, not impossible, but questionable that you would be impacted by it prior to. But that was never a blanket denial, so I want to make sure that that's clear.
Okay, it's very clear. Thank you.
Second thing that is clear is, unlike the first filers, this is a moving target because people continue to file claiming eligibility in February. For the earlier conversation, if they're found eligible, that's fine. But the number of people filing for February weekly claims continues to grow even this week and in the immediate weeks previously. Having said that, there is a chart showing the amount of claims that have been paid, it goes week by week, but for the week of February 8th, it's about 35%, February 15th, about 35%, February 22nd, also about 35%, February 29th, also 35%. So the rate of those claims in February is lower than the claims that are after February, but those individuals are still getting paid when they are determined to be eligible.
Mr. Thierman.
Is that Exhibit 4 we're talking about? Or I don't know which last exhibit he was talking about.
Mr. Rod, is this an exhibit to what was filed this morning?
It is, Your Honor. I apologize. I was working off a draft copy. So I believe it is page 3 to the data exhibit.
Which is?
Let me confirm.
I guess let me just ask counsel. So how many new people were paid?
Well, again, this is not a business meeting. So Mr. Thierman, what question is of concern to plaintiff at this point?
You asked if we're making progress. And I said we're not. We're not making sufficient progress. and then we go to the specific versus the general, which is kind of one of our little loops. We keep talking about specifics. They keep talking about general. We keep saying that due process applies to the individual. They keep saying we have all these indicia of fraud or non-eligibility, but it's not group-wise, but we're doing it in every single case, whatever.
Okay.
I mean,
But you-
I don't know if we're advancing. That's what
simple,
I'm saying.
all right, Mr. Thierman, you know, the editorializing, it's not helpful. I mean, I understand you're passionate. I understand people are hurting. I understand that there are issues here that the court's trying to address. But I want to say this again. For judicial intervention, directing another branch of government to do something that the law requires it to do, or to stop doing something that the law prohibits it from doing, is a fairly straightforward yet narrow ask. And so the court is trying to balance finding a way to help the people in need, but consistent with having DETR follow the law. So the editorializing, it's not helpful. I understand your position. Now, the question is, Mr. Ott, since the exhibit you referenced was attached to the filing that was just made this morning, the court has not had an opportunity to fully review it. The 35% numbers are 35% of what, please? Of all applicants that sought benefits for that period of time have been paid, or I don't understand.
So because it's a numbers question, if I could ask Chief Economist Schmidt to address it. I believe I know the answer, but he'll say it in a way better than me, if I could.
Right, thank you. If he's here, please come on board.
Okay. Thank you, Your Honor.
And you understand you're still under oath, is that correct, sir?
Yes, sir.
Go right ahead.
The 35% is the share of all of the claims that were filed for that particular week up through the latest data refresh that I got on Monday. So that excludes any claims that did not file for benefits for that particular week, but includes everyone who is paid, everyone who has any excess earnings, or anyone who has stopped due to an issue or a disqualification on their claim.
But what percentage then of those people are being paid? In other words, if they represent 35% of all claims, what percent of those people who are seeking benefits are actually being paid?
For those weeks, 35% of those people who filed for claims are those who were paid.
I see. And the reason it's not higher, as you understand it, is because they otherwise don't qualify?
That's correct, Your Honor. In part because of other issues that are identified unrelated to whether they filed for benefits in February or not. The group of people that is filing for benefits for those weeks has a higher share of other issues preventing payment on their claims. And so that's why those numbers are lower.
Okay. So, Mr. Thierman, the court asked that this issue be addressed today because it appeared at the last hearing and in the briefing that there was a particular bottleneck for people who were seeking benefits for the period of time, again, what I call generically, before the first confirmed case in Nevada was made. But as you heard Mr. Ott explain, there never was any cutoff, benchmark, or determination that benefits would not be paid from that point earlier. It was just a product of other factors. So what is the concern now unique to this group of people that you would ask the court to dial in on?
None. If they're being paid, they're being paid. And if they're being paid, if they're not being paid because there's specific indications that they weren't out of work because of COVID, okay. But I don't know if they were issued denial letters with an ability. I know they weren't issued denial letters with an ability to appeal.
Okay. Mr. Guanasso, let me circle back to you. With respect to the idea that an approach the court might take to move forward with some of the issues the court has previously ordered and to work through the issues the court is still contemplating, what would be the best way to use you as a resource and as a go-between with the parties here, in your estimation?
Thank you, Your Honor. One of the ways that I think I might be of assistance would be to facilitate communication between plaintiffs and defendants regarding, of course, complying with the court's order as it stands now, but then maybe working through some of these other pools of people who have not been paid. Presently, working with DETR, I've been able to provide them with samplings of those groupings of applicants who have had similar issues in the system.
Yes.
And I believe that process is going to yield some good fruit. For that is, it's going to get eligible people paid and help DETR identify potential process improvements. And if I could bring the plaintiffs into that conversation, kind of in the way that a settlement conference judge would, where we would have, collaborative conversations about how to get people paid and what the problems are, because as we talked about earlier, Your Honor, that maybe DETR doesn't have the manpower to go through the emails and receive the phone calls and talk to the people that show up at the office. But I know Mr. Thierman's office has taken that time, and I know that our office has taken that time. And so how do we take those voices and those concerns and get them to the attention of people that can do something about it? It might be a process that's similar to how you manage settlement conferences, but on an ongoing basis, where I'm able to work with Mr. Ott and Mr. Thierman in his office to ensure compliance first and foremost with your order, but then to work on the backlogs in these various categories to get with the ultimate goal to get people paid, because that's what I think everybody's shared interest, whether it's DETR or the plaintiffs or the court, is to get people paid. So how can we get there most efficiently? I believe that's through a series of ongoing conversations that I'm certainly willing to facilitate going forward.
I want to remind both plaintiff and defense that at this point, the court intends to allocate to each side 1/2 of the special master's and staff professional time, subject to further consideration after motion, response, reply, and a hearing. But for each hour that Mr. Guanasso and those assisting him work at the court's direction for the benefit of this case, there's an expense here. So we want to be judicious with the way he's allocated. Here's where we are, all right? Because this hearing's coming to a close shortly. Here's where we are. The purpose of the hearing was for the court to gauge compliance with the court order and to determine if progress was being made on those issues that the court declined to order the state to do differently at the last hearing. Understanding, of course, that the court could change its mind, and because the denial of the writ of mandate request on those other issues was without prejudice to renew later if good cause existed. At this point, I'm not in a position, let me state that another way. At this point, the court's not convinced that the court needs to amend its prior order or otherwise revisit the prior determination. The court is somewhat encouraged with the state's progress, both in its adherence to the court order and the effort it's made on the other issues that the court had and continues to have concern about. The court is encouraged to learn that additional resources, both human resources and technology advancement resources, are being deployed to work through the problems. The court continues to be concerned that the progress, however, under the circumstances that people find themselves in here in Nevada, are moving too slowly. Whether that concern arises to the level that the court finds that DETR is abusing its discretion or otherwise is failing to comply with its obligations under the law, we're not there yet on these other issues, but they're still in play. As a result, the court's going to make two orders now. The first is that when Mr. Guanasso, I don't know, Mr. Guanasso, if you are currently out of town on business, pleasure, or a mix, but as soon as your time allows, I'm directing you to work with both sides. If you determine it works best to go as act as an intermediary, great. If it's best to go sort of back and forth, also great. But to work and see where some of the inefficiencies lie, where the greatest degree of tactical change of approach might lead to better results, or otherwise assist the court in making a determination whether DETR continues to make best efforts to comply with the court order and make progress on those other issues. I would like you to undertake this over the next 2 weeks to file a supplemental report with respect to progress being made, if any, compliance with court order, to what extent, at the conclusion of this 2 weeks. And we'll have another hearing in this matter in middle August. If the court is convinced at that time that the progress is not being made or it's being made too slowly, the court will again reconsider whether to modify its currently existing writ of mandate or issue a second writ of mandate. Likewise, if the court is concerned that there is a willful failure to follow the prior court order, after this hearing in middle August, I will set an order to show cause hearing why the state of Nevada should not be held in contempt or otherwise sanctioned. That is the least appealing approach to the court. The court wants to avoid that hearing because the facts that would justify that hearing would exist. I want to avoid that at all costs. The alternative is much preferable to all involved. But remember, Mr. Guanasso is just one person, even assisted by his staff. There's only so much he can do. But he's going to act as the eyes and ears of the court to work with the parties to try to find some additional common ground, to assist with addressing inefficiencies, and then to report back. So again, Mr. Guanasso, just so we're clear, 2 weeks from today, between now and 2 weeks from today, please meet with the parties. Within 3 business days after that, please file a supplemental report. The court will have a hearing set. I'll give you a date and time right now, unless this date and time does not work for everybody. Court would like to have this hearing Thursday, August 20, beginning at 9:30 in the morning. We'll have the benefit of Mr. Guanasso working with the sides for 2 weeks. We'll have the benefit of the supplemental report. With respect to the motion that was just filed, Mr. Thurman, by your office last night, asking the court to deem the state in contempt, court will hold that in abeyance, as it will as well hold the state's obligation to respond in writing. With respect to the plaintiff responding to the supplemental briefing filed by the state this morning, The court will hold that in abeyance. Plaintiff need not respond in writing. If there's going to be a concern that there's willful violation of a court order, that will be a hearing that is set when we meet on August 20. We'll pick a time that works for everyone. You'll have a half a day, and I'll allow additional briefing and evidence, and there'll be a full-on hearing. But I'm not contemplating that for the August 20. August 20 at 9:30 in the morning will be another status hearing after Mr. Guanasso has worked his magic. So that will be the order of the court. I'm certainly willing to answer any questions that the plaintiff might have in light of what the court just stated. Mr. Thurman.
Two questions, Your Honor. First is, just so everyone's clear, my clients are destitute. So to the extent that this is not a cost item that I can, or that I'm not prevailing party, I don't know how he's going to collect his fee.
Well, here's my response to that. The court has authority pursuant to the statute and the rule to allocate the fees and costs of the special master in a way the court finds fair, just, and equitable. But the default browser is each side shares, and that's where we are now. Now, if you're trying to telegraph that expect a motion, it wouldn't shock me if one's filed, but I certainly wouldn't presume to rule on it in advance. Mr. Rod, what's the second question, Mr. Thurman?
Yeah, the second question is, as long as we're inching along, are we doing discovery or are we just waiting for these reports to flow out?
So to keep the cost of the process down, to allow DETR to utilize its resources to adjudicate and pay claims, I'd prefer that efforts be expended to that end as opposed to depositions, document requests, production, things of that nature. That's not to say those won't be in play after this August 20 hearing, but from now until then, I'd rather stay at the litigation in that regard.
Fair enough. I mean, that.
Mr. Ott.
I don't think I have any questions.
Okay, Ms. Jones?
No questions, Your Honor. Thank you.
All right, Mr. Guanasso, I guess I should have asked you. Can you devote the next 2 weeks to meeting with these parties and thereafter prepare a report within 3 business days? Because 2 weeks from today is a Thursday, and I figure 3 business days puts it into the following week. Then we'll have the hearing on the Thursday. Will that appear to work for the special master?
Yes, Your Honor. It'll work just fine.
All right. With respect to your professional services, what I'd like you to do is at the end of the calendar month, so after tomorrow, sometime in early August, as soon as you can put it together, please submit a request for payment by filing it with the court. Of course, redact any confidential communications to the extent there are any in the narratives, but identify what the professional fees and costs are through the end of July when you file something in August, and the court will take that up in short order. That's it. I want to thank everybody for the excellent discussion this morning. I look forward to having a follow-up hearing on August 20. And Mr. Guanasso, thank you for agreeing to assist the parties. Until then, the court will be in recess.